Welcome back to our last panel of the day. I've been really excited and waiting for this panel all day. I am just so delighted to be surrounded by this fantastic lineup of experts who have been engaged with legislative, executive, and regulatory efforts to curb perceived abuse of the patent system. We're going to have a format similar to Sham's format last, because I think we have such a wonderful, diverse group of opinions and viewpoints on this panel that I want to give them maximum time to discuss and debate. So I'm going to give some brief introductions and then try to lay the groundwork with one quick question to each panelist. And then I'm going to back off and just facilitate a discussion, hopefully for about 45 minutes to an hour, where I'd like to encourage the panelists to comment on each other's statements and even feel free to ask each other questions. And then we want to spend time at the end, since this really is the sum-up panel, to give you all a chance to ask our wonderful panel questions as well. So, in alpha order here, we've got alphabetical order. On the left side, we've got Patrick Coyne, who's a partner of Finnegan, Henderson, Farabow, Garrett, and Dunner. Did I get that right? Okay, and he's also the president of the Federal Circuit Bar Association. And just this past week, the Bar Association sent a letter to Representative Goodlatte emphasizing a concern about the bill, the Innovation Act, that many of the proposed changes are remedies that are already available to judges, and that rule changes in any event are more appropriately addressed by the judiciary. Next to him, we've got John Desmarais, who's the founding partner of Desmarais LLP, an IP trial boutique, and Round Rock Research, a patent licensing company. He can comment on litigation practices from his extensive experience, the impact the Innovation Act and other proposed legislation might have on litigation practices, and whether the impact is in our trial system's best interest. Next to him is Krish Gupta. He's Senior Vice President and Deputy General Counsel of EMC, a world leader in IT space. As he will discuss, he's generally in favor of the changes contemplated by the Innovation Act, and in fact, he was asked to testify before the House Judiciary Committee earlier this fall. Next to him, we've got Waldo Kuipers. He's the Corporate Affairs Manager of Microsoft Corporation. He's now living in Washington State, but until recently worked for Microsoft subsidiaries in New Zealand and in Australia. And while in New Zealand, he had a front row seat in the debate about whether or not New Zealand's patent reform bill should include a blanket ban on software patents. It's a fascinating story that he'll tell us more about in a moment. And then finally, to my immediate right, we're a little squished on the table here, is the Honorable William Sorrell. He's the Attorney General of the state of Vermont. He's gone on the offensive in his state, using state consumer protection laws to get an injunction against a certain patent assertion entity, which is sending cease and desist letters to Vermont companies. His state has also passed legislation giving companies the right to sue specifically patent owners that allege infringement in bad faith. So let me actually start with Krish, if I could. So in your opinion, why are we back in Congress considering patent reform when we just rolled out the AIA in March of this year?
Well, I think the AIA did not necessarily address some of the what I'd refer to as procedural changes that we think are necessary to deal with some of the abuses that we've seen in the patent system, and you know, part of what the AIA didn't get to is what this bill is hoping to address. First of all, I want to thank you, Cynthia and Christopher, for this invitation. I'm a last-minute replacement for someone who couldn't make it, and I found out that I was going to participate Tuesday evening. So I'm going to rely pretty much on, you know, the testimony that I offered before the House Judiciary Committee on the specific aspects of the bill that we at EMC feel are important and are needed. And it's, my views, I'm sure, are going to be different from those of John's. Although, John, I was with Mark Chandler of Cisco last night at an event at Cravat in New York, and we were talking about this panel, and he said, who's on the panel? I mentioned you. I hadn't met you till about a few hours this morning, and he mentioned that you had just won a big case for him in Texas. And so I'm interested to hear your views as you see both sides, both big company and small plaintiffs, if you will. So just to recap, the bill passed yesterday with a vote of 325 to 91, and there were 4 amendments that were passed as well. And the support behind the bill was bipartisan generally. To give you a little bit of perspective as to who EMC is, we're headquartered in Hopkinton, Massachusetts. We were founded in 1979 by a couple of engineers from Northeastern University. We have about 65,000 people in 80 countries worldwide, and our revenues are somewhere around 22 billion. And we also happen to have 3,600 US patents. We have a keen interest in seeing that our patent system is rational, fair, and evenly balanced. In fact, we create many innovations and look to the US patent system to protect those innovations. Since 2005, EMC has been sued by what we call non-competitor plaintiffs, and I'm not going to refer to people as trolls or PAEs or NPEs, over 30 times, and we have never been found to have infringed. As a matter of principle, we don't settle frivolous lawsuits, and defending those suits has cost us millions and has caused great disruption of our business, requiring our employees to shift their attention to, from designing new products to sitting in depositions and going to court. And I want to give you a little flavor of what a typical patent suit looks to us. For us, a typical patent suit involves a shell company with secret backers created solely to file suits. The plaintiff often sues EMC and dozens of companies in separate suits that get consolidated for pretrial purposes. The complaint is often vague and provides little information about the specific infringement allegations. When cases are consolidated, we lose some of our due process rights. We're forced to compromise on defense strategies, incur additional legal fees in coordinating with others. Furthermore, these plaintiffs then try to pressure us into settlement by demanding thousands of documents and emails during discovery, most of which are irrelevant to the suit and costly to produce. And if we want a decision on the merits, we have to typically wait 2 years, spend millions, and endure massive business disruption. Meanwhile, the plaintiff has nothing to lose, and they have typically lawyers who are on contingency and a steady income stream from defendants who have settled along the way. And faced with these choices, most defendants cave and are forced to settle, and we don't. And we're not alone in having had these experiences. Judge Rader delivered a talk on November 1st at the Eastern District of Texas Bench Bar Conference, and he noted that he saw that there were 2 avenues for continued improvement in our system, and he said one was administration of patent law itself. And the second area he identified was discouragement of litigation abuse in patent adjudication. And he went on to say that returning to litigation abuse, it is a real problem. And then he went on to identify some remedies and solutions. But the aspects of the bill that we support have to do with, first, we think that the bill has a fee shifting proposal. And we think that this bill ensures that plaintiffs have something to lose when they file meritless suits. We believe that the fee-shifting provision will strongly discourage the filing of frivolous suits. And I go back to what Judge Rader actually said at that conference as well. He said, and I quote, "Let me move on to the second judicial tool against litigation abuse," and he says fee reversal. And he goes on to say, "The potential of shifting fees helps to balance the playing field so that the wrongly accused at least has a hope of recovering their fees if they do not pay a nuisance settlement." And the second aspect of the bill that we think that we support is requiring the disclosure of a real party in interest and permitting the joinder of the party. These provisions were not addressed with the AIA. There's a provision that recognizes the need to strengthen specificity in pleadings in patent infringement cases. That's an important area as well. And also, it attempts to address the cost of discovery in patent suits by promoting and has certain features that allow stage discovery and for certain discovery costs to be shifted to the plaintiff if they need that additional discovery. So from our perspective, there are provisions in this bill that the AI did not get to address, and these provisions are important to restore some sort of balance and uniformity back in the system.
Great, thank you, Krish. Can I turn to John next to comment? I mean, is it really that bad out there? Do we need this bill? And there are, 9 others that were behind it between the House and the Senate versions. Really, is it timely? Is it relevant? And is it really that bad out there?
I would say yes and no. And let me start by thanking Krish for the nice comments at the beginning. And just in the interest of, so you folks know who I am, my main job is a trial lawyer. And in my entire career, the last couple decades, I've always done plaintiff side and defense side. So, and it's about 50-50, although that has varied over the last couple decades. So I am neither pro-plaintiff nor pro-defendant. I am very much pro-patent, though. So that's sort of my bias coming into this. It isn't for plaintiffs or for defendants. Mark Chandler's a good friend of mine, and I represent him, and I love his company, and I hope to continue to represent them. But my issue with the reforms is I do think it's bad out there, but the reforms aren't getting at what is bad out there. I think that I would agree with Krish and some of the others who spoke earlier today that there is bad conduct in the current patent system, and there are inefficiencies in the current patent system that create the bad conduct. So, and it's all been talked about today repeatedly, that litigation is expensive, any non-practicing entity can get their hands on a patent, file a lawsuit, and litigation costs millions. They'll sue 100 people and take $100,000 settlements. It's a great business. That conduct should be stopped. The conduct where a non-practicing entity sends out hundreds of letters with no diligence whatsoever, no study, just to sort of shake people down for nuisance value settlements, that conduct should be stopped. The bill doesn't get at that conduct in any sort of with any sort of precision. Instead, it attacks the foundation of the patent system generally. The fee-shifting provision isn't limited to that sort of conduct. It's to all plaintiffs. When you start changing the balance of the fees, attorney's fees, to be biased against plaintiffs, the ripple effect through the industry is going to be very troubling. Universities are not going to sue. Startups are not going to sue. Individual inventors are not going to sue. You can envision a scenario where a startup has gotten venture capital money. They maybe have a couple $1 million in the bank, and they're trying to launch a new product. They're trying to launch a new company. A big company can come and steal that technology. And now under this new bill, that company is going to be faced with the decision, do I try to enforce my patent and protect myself? If I lose and I have to pay fees, I will go bankrupt, right? When you start to look at the ripple effect of that, and we can go through each of the different things at the appropriate time. Another good example is the fee shifting and discovery. When you think about the typical lawsuit, the plaintiff needs most of the discovery. To make a plaintiff, if the plaintiff wants to find out how the infringer's product works, to make the plaintiff then pay for the discovery, it's not a fair and balanced approach to the problem, because the defendants are the ones with all the money. The plaintiffs don't have the money. They're not going to be able to do these suits. So without going one by one through all the reforms, my problem with the reforms is they're trying to correct a problem, but they're doing it by reforming the system, not addressing the problem. I think that has happened because, and one of the things that I'm actually very disappointed in the dialogue on this topic about is everyone's calling everyone a troll. It's name calling, it's derogatory, and it kills the debate. Because what happens is in our Congress, they stand up at the microphone and they say, we're going to stop trolls. Well, of course, everybody wants to stop trolls. That sounds very offensive. Why would you want to troll, right? And it cuts off the debate. And no one's talking about, well, what is a troll? What is the bad conduct? The bad conduct is, what Vermont's trying to get after with, endless demand letters or bogus litigation where you're just shaking down for nuisance value. That's what Congress should be talking about. And I can envision, I bet if we all got into a room, in 2 hours we could come out with a bill that stopped that conduct very precisely, like a laser, instead of this nonsense that's going to have ripple effects and hurt innovation all throughout our country.
Thank you. Patrick, can we talk a little bit about your letter?
Sure, but I'd like to answer the last question,
Sure.
if I might, first. And it's a real simple answer.
Go ahead.
Google. You asked why. Why is this happening now? There's nothing wrong with AIA. There isn't unresolved issues. Google has continued to lobby the White House for the last several years that they want to put an end to troll litigation. And what happened last time, why did AIA work? Because once you had the electronics industry in griping about patent litigation, you had a counterweight of pharma coming in, and there was a reasonable, as John just referred to, a reasonable, rational debate on the Hill. Okay, it took 6 years, but it was still reasonable, and it was still very well developed. What you've got is a group of conservative Republicans ramming a bill through in 45 days that is not well thought out, does not have the ample public debate and attention that it should have. And I mean, I could go down the list one by one. I would disagree with Krish. I don't think any of these things are going to be effective. Look at California pleading requirements. California judges typically do require pleading with particularity. What do you get? $50,000 worth of motions practice, and after 3 or 4 months, a great complaint. Okay, you just helped the plaintiff write a better complaint and paid for the process. What the second issue is joinder. The joinder rules were put in place to try to prevent these cases from consolidating in the Eastern District of Texas. What happens? The Eastern District judges look at it and say, well, wait a second, you're asking me to send these 17 cases out to 5 more districts? So there's going to be 5 district judges repeating the work I've got to do? And they made what, quite frankly, is a rational decision in terms of judicial management that, well, I can do it all here. Why do I want to burden 5 of my colleagues repeating that work? So if you go down this list, each of these things aren't going to solve the problem. We are literally killing the goose that lays the golden eggs. Why? Discovery. Discovery has grown. Why? And why has discovery grown? Why has it gotten out of hand? Because we are leaving advocates who are representing individual clients in charge and then complaining that the process is inefficient. Well, of course it's inefficient. It's an advocate system, which the efficiency is not the goal. One of the things that we had recommended is that, first off, the position of the association is really to try to defend, and I'll speak on behalf of the association, my personal views today. The position of the association is really to defend the court system, the integrity of the system. This bill is incredibly pro-defendant. As I've practiced more in California, I've come to appreciate over the years that the Northern District's rules, in my personal opinion, are incredibly pro-defendant. Why? All they do is throw down roadblocks in front of plaintiffs getting to trial. It doesn't improve the quality of the pleading. It doesn't improve the decision making. And I think you're right. Calling the ad hominem attack, okay, sure, Acacia sends out lots of letters. Sure, they'll settle for a couple $1,000. Katz did the same thing, and he made a very nice living off of it. But you know what? Thomas Edison was a troll. Nikola Tesla was a troll. Dean Kamen is a troll. Harvard University, Stanford University, need I go on? If you're targeting that ad hominem nature of that actor, you're going to get a bad result for the system. Why? Because what we're seeing is the development of a secondary market in IP. Okay, our system is expensive. I don't agree with John that we need the discovery. Germany, these other places litigate cases every day. They don't have this kind of discovery system. Frankly, my personal preference would be something much more like the UK, where you do get a fixed core of discovery, and you can go beg on bended knee for more if you can really prove you need it. And that would cut the cost of the system much more effectively than any of these other little tweaks we're talking about. You're seeing this secondary market. It's not pretty, but it is developing. You've got some players that, in my personal opinion, are fairly reasonable in terms of their approach, like IV. You've got some others, and I could name names, but I won't, that are not terribly reasonable.
Round Rock's very reasonable.
But that's really the problem. Congress is looking at this. They've given the courts tremendous authority over decades to administer the legal system. And what's happening is their constituents are coming in, complaining again. And unlike last time, no pharma doesn't have a horse in this race. They don't care. Okay, fine, it costs another $10,000 to draft a pleading on a product that's netting net profits at the end of its life of $10 million a day. I'm not going to be too worried about having to spend another 10 grand on how to get a better pleading on file. So you've got these, Congress is feeling frustrated because they've given courts authority. The courts haven't exercised them in a uniform, systematic way. Some have, some haven't. And Congress is, from what we're hearing on the Hill, the association, they are to the point of frustration where they're not going to give the courts more authority. They don't think it's effective. They're looking at solving the problem for them by case management. And that's where at least the Federal Circuit Bar is most vehemently opposed, is you're going to use a blunt instrument of a baseball bat in terms of managing cases with one-stop shopping. It isn't going to work. It's going to create a lot of problems, and just like we saw with Joinder, it's not going to have any effect at all. The Joinder rules came in, we have another 1,000 filings a year. And where are they? They're still in East Texas. It hasn't changed anything, and neither will most of these particular things. What we are fostering and trying to encourage the Hill to do is look at things like I was at a hearing in Alexandria this morning, and I was thinking about this topic coming in. What makes Alexandria work? Well, you only get 6 or 7 months to trial. That cuts the amount of stuff you can do. And you get the attention of a judicial officer, an Article 3 or Article 1 judge, when you need it, right away, within 10 days. So it's using the Rule 16 procedure, the Rule 26 procedure, more effectively to get early judicial involvement in the case, because you're not going to get efficiency out of an adversarial system where the parties are beating each other up. It's not, if John and I are against each other, it's in efficiency is the last thing on my mind. Winning is the first thing, but it's going to be on the judge's mind. And if they can come in and call those fouls, you're going to end up with a more positive result. Sorry, I went way too long.
Nope.
Great.
I agree.
I have to give General Sorrell a chance to talk here. He's going to explode.
Yeah.
Okay, please.
Well, Senator Leahy, when I meet with him next week in Washington, is going to be tickled to hear that he was essentially referred to as a conservative Republican at Penn Law School.
That wasn't the one I was referring to. And he's not from Virginia either.
And I don't know. It's entirely possible that Google has been calling the White House and conservative Republicans and maybe some liberal Democrats. But I know for a fact that any number of members of Congress have been hearing from the likes of Lincoln Street, Inc., a nonprofit in Springfield, Vermont, that brings home care to developmentally disabled Vermonters, and Eris Solutions, another nonprofit that provides fiscal agent services to Vermonters with disabilities to assist them in their daily living tasks. I think it was Professor Ferland said this morning that what she's talking about with her study of the litigation was the tip of the iceberg, and that the White House said that's, 10%. Well, that leaves 90% out there. And I can guarantee you that those two nonprofits were two of roughly 75 small businesses and not-for-profits that got these quasi-extortion letters from MPHJ, one of the 40 shell subsidiaries of MPHJ Technology Investment, Inc., supposedly out of Delaware but out of Texas, saying you've been scanning documents, you're in violation of our patents, scanning documents and attaching them to an email in a computer system, and be in touch with us within 2 weeks, or all bad things are going to happen. And then a second letter comes from the Farney Daniels law firm 2 weeks later. It says, oh, you haven't responded to the first letter, and now it's really getting serious, and if you don't call us within 2 weeks, litigation will ensue. And then the third letter from Farney Daniels attaches a draft complaint. Well, Vermont's 0.2% of the U.S. population, and unless MPHJ or its subsidiaries felt that Vermonters are more can be bullied or more naive than most, you want to take that and do the math from just this one outfit. That's 37,000 plus letters going around the country, and first cousin to the letters that go to the small local banks saying your ATM machines are using the web and you're violating our patent, or the local coffee shop that has free Wi-Fi, you're violating our patent, pay us $1,000 per employee right away. All of these companies and nonprofits are targeted because they're small, they don't have in-house counsel, they don't want to spend the X thousand to an attorney just to get an idea. And do they sue? Well, in our lawsuit against MPHJ, the first of its kind in the country, They certainly didn't sue anybody in Vermont. And to our knowledge, they didn't sue anybody anywhere in the country. But they are now in the tip of the iceberg, because my understanding is they filed one lawsuit a couple of weeks ago. So that's what the Congress is hearing. That's what AGs are hearing. And we're going to respond.
And then I'd like to give Waldo a chance to join in on the fray. Waldo, what did you see happen in New Zealand?
Sure, and thank you, everyone. It's a great privilege to be here and with this distinguished panel. As you can hear, I've got a bit of an accent that's a bit different to what you might typically hear every day around here. It's not because I've flown in from Seattle, it's because I was living in New Zealand until 3 months ago. So I've just recently moved to work with Microsoft Research, which is the research division at the company. But my previous role involved being involved in really supporting the business in New Zealand. And part of that led me to become involved in the patent debate in New Zealand. So I think I've handed around, and all of you should have, a few sheets of paper that just give a few illustrations of the story. I'll run through it very quickly. I realize it's a slightly different topic, and you have very interesting reforms going on right here in the US. But this is just a different story from across the Pacific Ocean. So if you travel a long way southwest from the west coast of the US, you'll get to New Zealand on the other edge of the Pacific Rim. And it's a small country. Since we're in Philadelphia, I'll just make a couple of comparisons with here. One is it's about double the size, it's got about 1/3 of the population and about 1/3 of the GDP. So it's a pretty small place, but very beautiful. Famous for hobbits, sheep and milk primarily. Now, you may have seen here in the States there have been some headlines around what happened in New Zealand. And if I quote from a couple of them, in a historic vote, New Zealand bans software patents. And another one, in the Washington Post, New Zealand just abolished software patents, here why we should too. Now, these are the headlines that were generated out of the debate in New Zealand. There's a bit of a backstory to all of this. As you might expect, New Zealand did have a patents bill that was a patents act, patent law that was quite out of date. New Zealand chose to follow the United Kingdom back in 1953 with a patent law, and that was until September the law in New Zealand. Now, of course, the rest of the world had moved on decades ago, and so there were a number of basic fixes that were needed to the New Zealand law. Those were relatively uncontroversial and got across the board support. After about 7 years of consultation with the public and 2 drafts of the bill, it then got to the final stage of consultation, and that's where there was a bit of a spanner in the works and the controversy really ensued. And this is when the committee decided that it would introduce an exclusion on computer software. Now, it's become, as this unfolded, this took a number of companies and others in the industry by surprise, because all the signals until that point had been that the consultation on software was complete and that in fact there would be no change. It also turned out that this particular wording was not what the officials had advised, and it was also not, it was also a little bit unclear what it actually intended, because the committee specifically referred to the fact they wanted to continue to protect the likes of washing machines and smartphones and all of the technology therein. It was just this idea of computer software that they felt was somehow different and not deserving of protection. The first company that really objected to this in New Zealand was actually a washing machine and whiteware manufacturer, Fisher & Paykel. They sell into the US as well under the brand Hire and under their own brand. And this company actually alerted me and a number of others in the industry and really asked us to get involved. And they said, you know, because for them, a lot of their innovation was in the smart software that ran the machine. And so they are the ones that really came forward and said, look, you know, this doesn't make sense. Even though the select committee has expressly said they'd like to continue to protect our type of innovation and that they valued it, this exclusion is too broad. So then the process went on. Now, the original Patents Act of 1953, as you might expect, did not mention software at all. So I've got a blank sheet in the presentation you have, which is the story on software patents in the 1953 Act. There's nothing. In the 1980s, the Patent Office in New Zealand started to receive applications for software, computer programs that, you know, inventions involving software. It took them 7 or 8 years to figure out what to do with these, and the first one was granted in 1993. and then until they continue to grant these with irregularity. Now, of course, the size of New Zealand being as it was, that means dramatically fewer patents than in New Zealand in the software space and in other spaces. And the litigation, which I'm hearing so much about today, it was less of an issue because, of course, scale-wise, the money that you can get out of somebody potentially is much less. There are patent trials that don't typically go in front of a jury. There's no treble damages. There are a number of other factors that affect the dynamic there aside from the scale. And in fact, as it turned out, there had been no, and there still has been to this day, no litigation in the courts relating to patent infringement. So this is the landscape in which we entered into this debate. The people who actually asked for this exclusion initially said that innovation in New Zealand was strong, rampant. New Zealand wasn't a place where it was really appealing for software developers because of there not being a lot of patent litigation. They also said that if software patents were introduced, it would be catastrophic for the New Zealand industry. Now, all of this kind of was quite interesting because, of course, there were software patents being granted every day, and they had been for a decade when they made all these statements. But this, in contrast to the great debate and evidence I'm seeing here, there was very little in the way of evidence at that initial point of the debate. As we went along, we then had various versions of this legislation come through. So first of all, the committee had literally said the proposal was a computer program is not a patentable invention. Debate ensued about what that meant, and as it turned out, nobody could quite explain it. Those few words, the officials tried to explain those few words in about 7 pages of documentation. There was a huge, lot of uncertainty about what that explanation meant, and the whole thing was obviously not workable. And so the government did eventually go back and introduce the as such wording, which echoes Europe. This still received a lot of objection from actually both sides because in one sense it was reducing potentially patentability, and on the other side it wasn't a ban. So after much debate, they ended up with an exclusion, you might call it, that's around a page long. But the intention of this, and if you read through it and look at the examples, you'll see washing machines are actually mentioned in the provision. If you read through that, fundamentally where it ends up is the UK position. And so that is in summary, that's where the New Zealand law since September has now ended up. And if you do want to look up some articles that are quite thoughtful about where that has ended up, and in fact read back on some of the debate as it occurred, the last couple of pages of the handout point to a couple of blogs that you might find interesting. The Patentology blog in particular has quite a good overview right from the beginning, and you can link back and see the whole story as it unfolded. So very happy to take questions. That's just a brief overview of how things unfolded in New Zealand. Thank you.
Excellent. Thank you, Waldo. Waldo, do you see any parallels between what happened in New Zealand and what's happening now in America? I know that's sort of unfair because you've been here for 3 months, but you have been listening all day, so.
I have, thank you. Look, I think there are clearly different issues at play in the US, and I know one of the issues that's been of concern for Microsoft is really the patent litigation and the nature of what's happened in the US. That obviously is a totally different issue in New Zealand, right, where there was no patent litigation related to software. In the US, there is, Microsoft is faced with around 70 lawsuits from patent assertion entities at any one time, and that's obviously a burden. On the other side, Microsoft has a very active licensing program. We have many licensees, both in and out of the company. I believe we spend $4 billion on licensing IP in, and we also have a great number of licenses out of the company. And out of that, there are only a very small handful of lawsuits, really with, in cases as a last resort. So I think, I definitely know that the company is supportive of the recent legislation that's gone through, but also there are additional reforms that the company is looking for around clarity of how claims are drafted using common terminology and making sure that it's easier to understand what the scope of a given claim is, and also in terms of the ITC. So That hasn't really answered your question. I see actually a lot of differences. I think the similarities perhaps are fundamentally, I think the people that are getting interested in the debate on both sides, it's very interesting for me to look at the incentives and the motivations and really see how it's affecting different people's businesses. And I think that, there's a whole spectrum there. I think one of the other issues I see is really it's important to think about what's the principled approach that is going to work and really addressing the nub of the problem, finding the real problem and fixing that rather than broad brush type of changes that will affect innovation and patentability of genuine inventions.
Great. I think that's a really nice segue. I'm going to go back to the whole panel. He says identify the real problem and try to deal with it. Krish, I saw you making notes as other people were talking. Maybe you'd like to start.
And would everyone please make sure to speak as directly into the mics?
Okay, thank you. So I'll offer a few comments. So Patrick, you mentioned that the Federal Circuit Bar Association's view is that this is going to be these changes are pro-defendant. I take that to mean that the Bar Association believes that this would essentially lead to a reduction in the number of lawsuits, right? Because plaintiffs are less likely to bring action, and frankly, I can see from a bar association's point of view, they don't certainly benefit from a reduction of litigation. In fact, this boon in patent litigation has been very profitable for lawyers both on plaintiff side and defense side. We've made a lot of law firms a lot of money representing us in these lawsuits. Two, let's look at this from a purely due process point of view, okay? So I'm a defendant. I have been sued for patent infringement. I think I have a right to know what product I'm accused of infringing, what product is accused of infringing, what claims of a patent I'm accused of infringing, and how is it that you believe I infringe. And from a plaintiff's perspective, they should have done that work as part of their Rule 11 pre-filing diligence in any event, so we're not asking for any more information beyond that. And by the way, we are plaintiffs as well, so we understand that these rules, when they're implemented, will apply to us just as much as they apply to the other side. Second, I think if you look at sort of who's been raising this issue, I think it's unfair to put it entirely on Google. EMC has over the years, I've gone down as part of the IPO, which is an organization that I belong to. I'm on the board and the executive committee, and we've gone down to meet congressmen and senators representing various industries, pointing out that we need some reform. And at the end of the day, most of your clients are actually the ones speaking with congressmen and senators asking for those changes. At the event that I mentioned yesterday at Cravat, the general counsel of Eli Lilly was asked the question that if there was one particular provision in the bill or words to that effect, which one would he support the most and he thought was most important. And if I heard him correctly, he said it was the fee shifting proposal. And in fact, he was asked if there was a particular aspect of that proposal that he would change. He said he would actually remove the discretionary part of it and make it mandatory. So, it's not about trolls, it's not about big companies. Pharmaceutical companies like Eli Lilly are plaintiffs in many cases, and they understand that those rules would apply to them just as much. And I want to also point out something that I think, John, you mentioned about fees. And small inventors and universities, the proposal that Chairman Goodlatte's bill actually, the language in the bill actually says that unless, that the court shall award a prevailing party reasonable fees and other expenses, and then it goes on to say, unless the court finds that the position and the conduct of the non-prevailing party or parties were reasonably justified, so that's an out, in law and fact, or that special circumstances, such as severe economic hardship to a named inventor, make an award unjust. So it's not a loser pays system. It actually gives the judge an enormous amount of discretion to decide whether it would be unjust to award fees to the winning party. So,
Patrick?
Would you favor a system that was more like the copyright law, where it is truly loser pays if you are the prevailing party? My concern, I'm not speaking on behalf of the Bar Association on this issue.
Patrick, excuse me, can you speak into your mic?
I'm not speaking on behalf of the association on this particular point, but if you have a system, for example, the first iteration of Goodlatte's bill was substantially justified. A new sui generis term in law, at least in IP cases, that it's going to take a generation of construction to figure out what it means. There was griping about that. So during the course of the development of the bill, it was changed to reasonably justified. Yet another sui generis term that we're going to have a generation of cases that have to decide. I personally am not necessarily opposed to fee shifting. I think it would put a very healthy discipline. But why not employ the entire body of copyright law that's been out there for 35 years that has a very well-developed idea of who is the prevailing party and shift the fees to the prevailing party. Instead, we're creating this hodgepodge to try to deal with a legislative compromise that is simply going to breed more litigation. In terms of the breeding more litigation, I do take umbrage at the first comment. We're not the pro-litigation association. We are the Federal Circuit Bar Association, and what we are trying to do is improve the administration of justice. To me, it's an issue, getting to your second point, of fairness. Right now, these proposals are biasing. There's a perception that the asymmetry of this warfare is unfair to defendants. Well, it being asymmetrical doesn't make it unfair. But certainly some of these procedural fixes that are being discussed are going to tilt the playing field very, very definitely in favor of the defendants. There are other ways to deal with the unfairness of some of the issues for the plaintiffs. And you're right, the pleadings are fine, but having $50,000 worth of pleading practice is not what I want to see on my tombstone, that, wrote really good motions for a more definite statement. The court could be given the authority, and this is what we're proposing, that in conjunction with the Rule 16 conference, don't make it the parties submitting a stipulated agreement and the judge says, hey, that looks great, have a good day. Have findings. Require the court to come in and make findings. What is at stake in this case? What is the value of this dispute? If the value of your dispute is less than the defense costs, if it truly is a stick-up for $1,000, you ain't getting any process. Okay? And the defendant's you're not going to be able to force the defendant to undergo compulsory process. That would be personally what I would prefer to see, to manage the cost of litigation in proportion to what's at stake. If it is a $1 billion blowout case with a $10 million a day profits on a pharmaceutical product at end of life, fine. Have all the process that everybody wants. Chianti for everybody. But if it's a situation where it is truly a stick-up, the court has and should be encouraged, and the Congress could put effective bills in place to make the courts use that discretion in a constructive way to limit the process. But to do it as a one-size-fits-all doesn't work. And I do applaud the effort to use the consumer protection laws on some of these letter-writing campaigns. Having been the victim of many of them in my career, it is a nuisance, and there is tremendous. You're going to go back to the CFO and say, no, I want to spend $5 million defending this case when you can get out of it for 10 grand? You'd be violating your shareholders' rights to even consider fighting it. So there are other ways to come at this other than a blunt stick of modifying the case management role of the courts and requiring them to try to put everything in one box.
And can I
Go ahead, John.
kind of pile up on them also? I think if you're really trying to get at bad actors or people who haven't done a Rule 11 investigation or people who are asserting a frivolous patent, what would be wrong with leaving the patent litigation system just like the rest of the litigation system in this country and just encouraging the district courts to do what they're supposed to do under Section 285, which right now says if it's an exceptional case, you can award fees. It should be the law, in my view, that an exceptional case is one where somebody didn't do a Rule 11 violation or the assertion wasn't colorable or it was frivolous. I mean, I think we should be encouraging the district courts to use the fee-shifting statutes that are already in place, and that would get at the conduct we're worried about. And on the complaint side, I think what's unfair about requiring a very detailed complaint in all circumstances, if you have, not to keep picking on poor old Google, but a lot of the stuff that Google does in their back office and their servers, you can't, no matter how much investigation you do, get the details of that on Microsoft's software. There are, it's next to impossible to do a pre-filing investigation in detail and get at Microsoft's code and figure out how they're doing it. That's why we have notice pleading. The reason we have notice pleading in this country is because if you have a good faith belief that there is a violation of your rights, you're entitled to your day in court, and there's a discovery process for you to figure it out, and you're either right or you're wrong. You need to do some level of analysis, but why are all the provisions in this bill one-sided prejudice against the plaintiff? You want transparency? You want a detailed complaint? Well, then the flip side of that bill should be, and the defendants have to tell the plaintiff at the beginning, how does your product work? Do you have any other products like this? If we want transparency, let's get it out. Why are we hiding patent infringement behind procedural rules? If we had a system that was transparent, the defendant should have to share and the plaintiff should have to share, and maybe these things would go away.
General Sorrell.
You've got a...
Oh. Can I ask one?
Nope. I just wanted to say, if the Innovation Act or something like it were to become law, would you drop your suit? Do you think it would take care of what's going on in Vermont?
Oh, no, not at all. Our suit is for unfair and deceptive acts and practices in commerce, for making statements in commerce in Vermont that are just outright untrue, lack of due diligence before sending the threat letters, on and on and on. And, Vermont also, our legislature just this spring passed a statute for bad faith assertions of patent infringements. That's not the basis for our lawsuit. Our lawsuit was filed before the statute was enacted. But I think, well, speaking for Vermont, but I think for a number of the other AGs, whatever comes out of the Congress, and I certainly don't pretend to be an expert on patent law and all the nuances of this section and that section and what's going to happen down there, but quite frankly, a bad situation affecting many of our constituents has been allowed to develop that doesn't involve litigation, abusive litigation tactics and such. And we hope that the Congress, among other things, makes very clear that state enforcement efforts of our Consumer Protection Acts are not preempted, and one of the things that's happening in our lawsuit right now is they're saying we have no personal jurisdiction over them because they're essentially citing a federal case that doesn't give personal jurisdiction over them, and we're saying the patent is only a vehicle to violating our Consumer Protection Act, and there's not a shield that you can do anything you want in state without the reach of our Consumer Protection Acts just because it relates to a patent. We'd love the Congress, because the Council of State Governments has looked at the Vermont statute and approved it as a so-called model act. So I think it'll be interesting to see how many state legislatures take a look at a Vermont-style act for a private cause of action for bad faith assertions of patent infringement with treble damages and this and that and this and that. It'll be interesting to see whether those get some legs, and we hope the Congress will not take away the authority for those statutes to play out in state courts.
Can I ask you a quick question? I don't know a lot about the facts of your case, but hypothetically, let's assume the letters that went to the local coffee shop for using Wi-Fi.
Oh, this was all the scanning documents in our case.
All right, so say scanning. So went to the local shop for scanning. Let's say that the patent actually was valid and the patent was actually being used in the scanning. Is it your lawsuit's position that is still bad act?
We're well aware of federal preemption, and what a patent controls and such is a matter of federal law, and we framed our complaint very carefully not to go there.
Okay, so it's just because
it's the statements they made in their letters. For example, if you don't pay us $1,000 per employee, agree to do that within the next 2 weeks, litigation will ensue. And we waited, and we first sent the CID to them, they stopped sending letters into Vermont. But we waited months and months and months, and they didn't file any lawsuit. And then what answers they did give us to our CID gave us the basis for suggesting that they hadn't filed any lawsuits anywhere in the country. And so that, among other statements, was just outright untrue, and we contend. And our Consumer Protection Act, corporations are consumers. That's not the case with all state acts, but it is the case in Vermont. And we said just unfair and deceptive acts, statements, and violates our law.
Apparently, you're proving my point, which is we don't need reform because we already have in place laws that will protect local companies.
Well, someone sat on their hands and let a bad situation get worse, and now the Congress is responding, and hopefully the states will respond.
You got another round.
Go ahead, Patrick. I'm going to give the panel just one more minute to wrap up if they've got comments for each other, and then I promise we will open it up to the floor for questions.
I mean, as much as what I've said earlier, I mean, the bottom line is I think reform at this stage in this Congress, in this term and session, is inevitable. You've got a very highly motivated House. You've got a very highly motivated Senate. And personally, I'm intrigued by the tactics of the Senate bill. If you map them all out, none of the provisions in any of the proposals overlap, which tells me that the three chambers have coordinated and they've got three bills they've dropped, seeing what'll pass, and then they'll bring them all back together in conference, and it'll pass out at the conference right away, which is something that could happen on the Senate side within a month, given the holidays and all. But it's pretty clear to me at this point in this debate, something is going to be passed, and it's a question of what it is. Is it going to be something that is a blunt instrument that really torques the court's case management ability and makes the problem worse, like the joinder rules have turned out to be? Or is it going to be something that works with the courts, works with the Rules Enabling Act, allows the courts to manage their own dockets, but does it in a way that's more directed? And that's why we're proposing this Rule 16, Rule 26 should be the focus, to get more judicial involvement early in the case and get case management in a more effective footing, rather than 15 different disparate provisions that, at least in my personal view, aren't going to work.
Krish, did you have a final comment?
Just two things. One, in some ways, I know that the joinder provisions led to a massive increase of number of suits. Mm-hmm. But again, purely speaking from our experience, because of those joinder provisions, we have actually been successful in transferring cases out of certain places. And it really is reflection on the plaintiff, because the minute the case gets transferred, they drop you. And they have because it doesn't fit the business model. The second thing I'm going to say is that, I know that, again, I point to Judge Rader. I mean, he talks extensively about the fact that there is an imbalance in the system. And it is that imbalance that has caused the abuses that we see today. And I think, he had in the op-ed piece that he authored for the New York Times and even in his most recent speech, I think he talks extensively about the fact that fee shifting, or fee reversal as he calls it, is an important tool, and he's encouraged federal judges to take advantage of that tool that they already have today. But he can't get any of these judges to do anything, and which is why we have two cases before the Supreme Court today, and the Federal Circuit is looking at one. So, you talk about new area of law. Well, we're still struggling with what an exceptional case is, right? So why not change the standard, and we'll get it. We'll be at it again. I think you have to have some balancing of interests. When Google and Apple, or Google and Microsoft and these companies litigate against each other, there are normal checks and balances. We're plaintiffs. We started out as a very small company. Our competitors were IBM, Hewlett-Packard, Hitachi Data Systems, much, much larger than we were. And they sued us for patent infringement, and we fought them with our patents, and we prevailed. And we completely value and understand the value of patents in our society as innovators. And so we're not about trying to demean patents or disrupt the system or make it one, but we as users of the system are going to have to pay. Ultimately, we're the ones paying, the corporations. We pay all of the attorneys' bills.
Well, you pass on the consumer.
Not necessarily. In high tech, you tell me. In high tech, when have you seen the cost of a product go up? In technology, prices keep coming down because that's the nature of technology. you buy phones and iPads and laptops, every time you buy a new one, you paid less than what you paid for the prior version. So, it is real expense for us. At any given time, our company has about a dozen pending lawsuits. When nothing goes on in litigation, and John and Patrick, you'll probably attest to this, just from normal daily sort of routine activity, it is not uncommon to generate a $50,000 bill. So then so if you got a dozen suits pending at any given time and you're paying $50,000 a month, you do the math. And how many engineers in a company make $50,000 a month? We could hire a dozen engineers per month and pay them for what we've spent on patent litigation. And I'm telling you, in my time there, I've been at EMC for 16 years. We have never, ever found to have infringed. We have taken cases to trial. We've taken one on summary judgment. We've won a trial. And so we're not hiding infringement. We don't settle because when we find that one of our companies is RSA Security, a pioneer in security technology. VMware, which is a pioneer in virtualization. EMC pioneered the enterprise data storage business. So, we have a lot of prior art, prior products, prior processes, and we take a great deal of pride in standing behind our innovation and our research and development work.
Let me open it up to the floor for questions.
Yeah, I'm going to start with a little story. Listening to this thing, I hear all of the critics, and I say, I think you're right. Then I listen to all the defendants. I say, I think you're right. And the rabbi comes along and he says, how could this be? And the rabbi then says, you're right too. What this means in effect is the analytics that I think has not been articulated by anybody in this discussion is how you deal with two kinds of error, both of which could be large. And so if you just select the anecdotes in which they're false positives, you will get one very powerful view of the story. If you select the anecdotes with the false negatives, you will get a very different story. If you put both of them together, then in effect they don't cancel each other out, they accumulate. So the issue is, how do you figure out a way in which to minimize the sum of type 1 and type 2 error, is what I take out of this discussion. And this is the response that I would give. I think the single greatest mistake in the history of civil procedure came in 1938, when they announced in the rules of pleading and discovery that everybody knows that litigation is a cooperative search for the truth, so that what we do is we allow people to have maximum discretion so as to correct innocent errors, and we don't worry about strategic behavior. That was essentially the mindset of a very bad year generally, 1938, New Deal fervor, and the whole rest. My view is, and I think this is closest to Patrick's position, I think the rule which allows discovery to begin on motion by the parties without judicial oversight is the rule that must be changed from beginning to end. That gives you, in effect, the way to neutralize the big gun that could otherwise be done, and it changes each and every feature of the case. And the second kind of thing I think that one has to do is you start developing rules that at that time limit the amount of information that you could get with the initial dump, and what the function of the judge is to say, tell me the 10 things you want most, and when we look at those things, we'll do it second. It doesn't have to be the judge to do it. It could be a magistrate under the supervision of a judge. This should be done everywhere with respect to civil litigation. If you think about it, it is perfectly symmetrical with respect to the two parties. But essentially what's going on here is one guy says, I'm allowed to launch my haymaker, and you're not allowed to launch yours, and the other guy comes back and says it the opposite way. If we have these amounts of divergence between private and social costs through the current system of litigation, then the appropriate thing is you've got to get somebody in the middle who essentially shortens it. And what's the tragedy of this is everybody wants the fix and nobody wants the fundamental reform. So my question to you all is, why is not a revision of Rule 26 on this particular point the way to go, given what I've just said?
I think what you just said would dramatically solve a lot of the issues, and it is a very easy fix. And I certainly would prefer that to the fix they're trying to run through.
This is trying to fly an airplane with one wing.
And I would agree completely, because I've already said it 3 times.
That's
Rule
what I thought you were
16
saying.
and
You
Rule
didn't say
26.
that, but everything you said was consistent with what I said.
Rule 16 and Rule 26 are the keys.
Yeah, that's right.
If you have a limited amount of discovery and require the parties to justify it on bended knee, then the judge has control over it and can make sure that the amount of discovery is proportional to the needs of the case. And that's not the current system. And that's the leverage the plaintiff has to accomplish these abuses.
Or the defendant to freeze a case. Well, you've heard the expression, defendants know how to ice cases. And sometimes they get to do their discovery first, if I'm not mistaken, at which point you get the strategic thing. So I'm going to ask the Attorney General.
I might be missing it, but I don't think that does anything for 90% of the iceberg.
May I ask why?
Because they don't sue.
No, I mean, look, the point is when they threaten, I'll tell you that what you do is you say, whenever you have a complaint, you must attach a copy of the following rule, which says that no plaintiff can have discovery without the permission of a judge, and give it to the defendant. What I'm going to do is combine a consumer protection rule, which I will let you draft, with the pleading rule, which I will draft. And then between us, I think we will be able to control both types of error by adding in a little bit by way of administrative cost. I mean, I think, in effect, that if you understand that standard theory is bargaining in the shadow of the law, and what I want to do is cast a larger shadow over what I think to be bad actors. So, I mean, I think you should be on my side, sir. Maybe?
I'll take that under advisement.
Another question.
So one comment, I think that all makes perfect sense, but the problem is, of course, that requires a rule change, and different courts have different rules. So in the Northern District, you don't need what's being infringed in the complaint. You got to do it pretty soon anyway. Other places, it can take a long time. In some places, you get your claim construction ruling right away. Other places, you have a hearing maybe someday, and then maybe a year later you get the response, and meanwhile discovery accumulates. I think what we're seeing a lot of is Congress saying we've got to make this standard across all districts, and one of the complaints we're hearing from the defenders of the court is you're telling the courts how to do their business. And I think what Congress is saying, yes, we are telling you how to do your business because the way you are doing it is not working, at least some of you. For good or for bad. I guess the question I have is on the demand letters, assuming that it's a valid patent, and I don't know that it is, my gut tells me it's not, are we saying that sending a demand letter is a violation of consumer protection? Is it like canned spam where only if you send a demand letter to so many people? But what if your technology is fundamental as scanning to email is, such that everybody is infringing? How else are you supposed to enforce it? Or is it the fact that they're asking $1,000 a user, which is a ridiculous amount?
Not per user, per employee.
Per employee. Well, which I assume is a user, but sure, $1,000 per employee.
Basically, it went to nonprofits and businesses with less than 50 employees.
Well, yeah, I agree that it's a ridiculous amount of money. The point is,
there's nothing that Vermont has done that's anti-patent.
No, I
It's
understand.
anti-patent abuses.
Right.
That's what we're trying to address.
So the question I have is, what is the abuse? Is the abuse sending a letter with no intention to sue? And I worry about the perverse effect of that, because what happened the last time we had something that said that made it problematic to send a demand letter, the amount of lawsuits without demand letters went way up, and people still complain about that after the MedImmune case. So if we now outlaw sending, now may get rid of the MPHJs.
We're just asking you to be truthful and not deceiving in the statements you make when you're engaged in commerce in Vermont, whether it has to do with patent or not.
So if they leave out, and we will sue you, then it's okay?
They're going to have to change their business model a little bit. I'm not going to do the work for them. We hope they stay out of the state.
Good luck with that.
Other questions? Yes.
At the risk of changing the topic a little bit, in terms of New Zealand, it's not clear to me, I'm not sure, but it's not clear to me that the standard's any different from what it is here. We can't patent software per se, or as such either, patent software rather. And the wording makes it sound like more of a prior art issue than a subject matter issue.
Sure, I think you're right. I'm not a US patent law expert or a UK patent law expert, but what I've heard from people that do filings in these markets and observe litigation in these markets, the New Zealand rule shouldn't substantially mean different patentability in New Zealand than in the US or in Europe. So the patentability rules, although it's a very lengthy provision, you know, the substance of it shouldn't make that much difference. I think where some people have commented there may be a difference is in terms of business methods that are implemented in software, that they believe those don't meet the test anymore necessarily. That's probably where there's quite a bit of a grey area. And there is actually an example in the statute that gives a very simple business method example. Now, there's a very, very simple, obvious one, so it's not a very helpful example in that sense, but you're quite right.
Wasn't it true that there had to be compliance for trips as well? Didn't it have to come into?
Sure. One of the, and this is speculative, but New Zealand obviously is a small nation and it's a trading nation, so it depends very heavily on international trade for its economic success. And one of the considerations that the officials certainly had as they were advising the legislators were, you know, what are the international trade implications? And you can read it all in their advice, which is now published. And certainly the alignment with the UK at least means that they're in the same boat with another country and not doing something out on their own. So.
Other questions? Way in the back.
So I actually just, I just wanted to tell the Attorney General, MPHJ actually did sue once before they were MPHJ. It was a previous incarnation. They sued a company called Blue Wave Computing in Georgia.
Is that the Project Paperless?
Exactly. That's when they were Project Paperless. So they sued once. He came up with prior art, filed an answer, and they immediately dropped the case.
Right.
Yeah.
But as MPHJ or one of their 40 shell subsidiaries, they hadn't sued until recently. Yeah. But you see, we don't know that for sure because they've been resistant to answer all of our CID inquiries. And, of course, we're now in discovery, and we hope to get some answers.
So I was interested in the panel's view on a different provision of the Good Lot Bill, the one involving the customer suit stays.
Well, this would go part of the way to eliminating the Attorney General's problem, is that if you could, and you know, this is what happened in the Katz cases. That Katz was at the end of term on the last set of patents they were litigating on scanners. Were going after individual retailers and, you know, shaking down 7-Elevens for $1,000, $1,500 a pop. And what ended up happening is the two manufacturers finally ended up intervening and taking over the litigation. And that is actually, my personal view, a fairly effective model. And that's what this would cause. This provision, we're not against every single provision in the Good Lot Bill. But what we are against the association is against the judicial management, the case management provisions. That is a particular provision that I think could be a very effective model if it were implemented in an effective way. Now, what if you get a manufacturer who doesn't want to be part of your party? Are they going to be compelled to be joined? And the current bill simply says, well, you can join them as long as it doesn't mess up jurisdiction. Well, okay, I'm just going to sue in a state where the manufacturer is going to screw up jurisdiction, and I'm going to prevent it. So the current proposal, I don't think is going to be effective, but the general concept, I think, could be if it were implemented in a different way.
I have a little bit of a different view on that. I think I agree with the general notion that manufacturers should, if they can, defend their customers. But it's already happening now in the United States. The way it works now is if your customers get sued and you are the manufacturer selling them products, you're ordinarily indemnifying them. So they call you and they say, take over this case. And in my practice, I've gone in many times where the manufacturer is paying me, but I appear for the customer, I defend the customer, the manufacturer pays for it, and we get out of the lawsuit or we try the case. Sometimes the manufacturer will file a declaratory judgment and move to stay the customer case, and that happens. And in the current system, so the current system achieves what that bill was trying to achieve, but it leaves to the district court on a case-by-case basis, do I stay the customer suit? Do I let the manufacturer suit go? Or what have you? How to play it out? Why is that important? A lot of patents are in fact, the value is in the use of the invention. You may have a patent that talks about a method of doing something or a system where all the value comes into the end user. So take, for instance, something I'm familiar with, which is the RFID space, radio frequency identification. Walmart uses that technology or plans to all throughout its stores. They've done analysis on the value of the technology to Walmart. They have calculated how much the technology is worth to Walmart, and they say we've stopped thefts throughout all our stores around the world to this amount of percent of our annual revenue. We have been able to restock the shelves more quickly, and that has this percentage effect on our revenue. So they've gone through this calculation, and at the bottom they say, okay, so we've made this many millions every year because we use RFID technology. Now, if you have a patent on using RFID technology to manage your inventory, prevent theft, why should you, as a patent owner, have to sue the manufacturer who makes an RFID tag, sells it for a penny, or the manufacturer that makes an RFID scanner and sells it for $10, when all the value of the system and the use is in Walmart's use of the invention? The Patent Act prevents unauthorized use. This bill kills the value of patents like that, and why should it be mandatory that patent owners who have those sorts of patents lose all their value so that the manufacturers could come in and defend?
Is there anyone that hasn't asked a question that would like to ask a question? Closing you off.
Yeah.
Okay, go ahead.
I mean, because, I just wanted to pile on with what John said, is that what happens is when you pass this legislation, you have a trope in your mind of a giant manufacturer selling to little retailers. But there's nothing in the bill which limits it to little retailers, and Walmart is, in fact, a downstream user. And so for many cases, you're never quite sure which end you want to go on. So to give the inverse type situation, suppose there's a surgeon who uses a technique and there's a company that sells it. At this point, the distribution is in exactly the opposite direction, and you're much more valuable to you to bring a contributory infringement action against the distributor than it is against all these individual surgeons. These are all case-specific kinds of variations, and you have to do this. And the problem about drafting legislation by listening to particular complaints by individual groups is that what you tend to do is to draft the thing that cures the problem, and you never worry about overbreadth with respect to the way in which this particular problem turns out to be cured. And, it was striking. Nobody has mentioned this, but, we talk about, guys getting really upset on Main Street. Last count I looked on December 3rd, there were 40 letters by 40 different kinds of institutions which said this bill is going to murder us with respect to activities which have never generated a single complaint by anybody else. And I think if somebody disagrees with that, I guess this is most the Krish Gupta, don't you think those guys are entitled to something by way of protection if their business models are going to be shattered, and that somehow or other that has to be something that you take into account when you propose something not as firm practice but as legislation?
Well, I didn't comment on customer stay, so but I'm happy to. It's a complex problem, and I think the bill was not necessarily suggesting that the patent holder cannot recover value against Walmart for their use of technology. And let me finish. So how is Walmart, if the claims are directed to the RFID technology and the manufacturer somehow is not able to intervene and defend the suit, assuming that they want to, Walmart is in no position to defend that suit. They don't have access to the design documents, the technology. They simply happen to buy something off the shelf. And they're using it in their environment as a user. It's no more than you being able to defend a lawsuit against your Wi-Fi equipment at home because you just don't know, but you're a user, and maybe you are generating a lot more profits from your use of Wi-Fi based on a business that you're running out of your house. So the point is that there has to be something that goes to sort of reducing the number of suits that are filed to promote some efficiency in the judicial system. So we end up being we find ourselves on both sides. We buy computer chips that go into our products. The infringement might be entirely directed to a chip that we bought off the shelf that then happens to be put on a board that we buy. We have no insight into how the chip is designed, and we get sued. And the question then becomes, how are we even able to defend that action, because we have no design documents related to that chip?
Well, look, this is a problem which comes up in every product liability suit, or in every pharma suit, and particularly under current law where you could sue retailers for manufacturing decisions and FDA applications, so it's not unique. But one of the things about Walmart is, having you mentioned it to me, I suspect they figured it out, and before I'm going to get too sympathetic for anybody on this issue, I'm going to ask whether or not there are defense and cooperation obligations that are part and parcel to the original sale. Now, I don't think that's likely in the case of buying a single component of a larger assembly, but if you're buying an RFID system or something like that, I'm pretty sure there are some kind of cooperation obligations that go along with the sale. And the point here is, just to stress it again, is that a lot of the coordination of defense issues can be solved by contracts. And what's happened is, if this thing comes as a surprise in the first generation, what you don't want to do is make the evaluation on that the private responses in the zero generation, which are inadequate for the first generation, is going to be to the state of the world. These contracts the next time round will be completely different, and all of those problems can be solved by private coordination. And yet, in all the talk about the Goodlatte bill, I have not seen a single word which starts to figure out what kind of self-help and organization methods are available. One other point, the problem here is, suppose it turns out you get the state.
You've got two questions behind you, so I'm cutting you off in 30 seconds. Does the panel want to respond before we go to the questions in the back? Okay.
This actually responds to that. Or, go ahead, Matt.
Yeah, so I just want to talk about the bill, because since I know it pretty well. The customer stay provision is consensual. The customer has to agree to be bound by the result. So this is not a case of Walmart being able to get off scot-free. They still end up getting sued. But I would also like to point out, as I think Krish was getting at, why is it that the patent holder is somehow magically entitled to the profits that Walmart made using a device that it simply purchased? When the device was invented, this RFID tag, I'm assuming, let's stipulate that patent application does not suggest the use to which Walmart put it, or certainly not to the extent. So they're now getting the benefit of a use that they didn't contribute, they didn't suggest, of a device that...
I was postulating the patent claim being using an RFID system in a store to manage inventory. That was the patent claim that I was postulating.
And John, what that does is, and this is where I think you're right.
But John, does that actually disclose how to make an RFID tag, or that's...
In the specification, yes.
So this is not simply somebody saying, oh, I can take an RFID tag that somebody else made and I can use it in a store.
In the hypothetical that I was postulating, which is actually an actual case, the specification discusses how to make an RFID system technically, and then the claims talk about different uses of it. You can use it in a store to manage inventory. You can use it to manage, to prevent theft, that sort of thing.
Mark,
and
did
then
you?
It talks,
Go ahead. Mark, did you have a comment?
Yeah, I understand Richard's point that with some amount of transactions cost, you can solve some of these problems by contract, though I suspect he doesn't in fact know which parts in his car have given him an indemnification provision against patent infringement. And while you could contract for that, it probably isn't in the world's best interest to do it. And so part of the problem I have is this business model is designed precisely in order to increase transactions costs, right? It's designed to increase the number of transactions that have to occur. I sue a bunch of customers instead of one manufacturer to make it more difficult for those suits to be resolved. That's not just an accident that maybe we could minimize with contract. That is the point of the business model. Now, I take John's point, and I think one ought reasonably to distinguish between use of a patented product which is, I think, at issue in these business method cases, and a patent claim on a method of doing something where the direct infringer is the downstream person. If you want to sue the direct infringer who is the downstream person on a method of use, I think you've got to be able to do that, right? But the cases that the bill is worried about are cases in which I bought a scanner and the patent is on the scanner, and rather than do a license with the manufacturer of the scanner, I want to send 10,000 letters to people who I think some of which I can get to pay $1,000 to go away. We had this discussion in the last panel about clearance and the costs of clearance. This seems to me precisely designed to increase the cost of clearance by increasing by large orders of magnitude the number of people who would have to engage in that clearance.
I think we have time for one more question, the last 2 minutes of the conference, and it's yours.
Okay. Would anyone like to comment on what happens if legislation similar to the Goodlatte bill passes in an attempt to fix troll abuse in district court? What happens in the ITC with no reform?
He's gone.
Yeah.
With no reform, the ITC is going to keep going because it's got a different enabling statute, and the statute does not say according to the rules of equity. It says if there is a violation, the commission shall issue an exclusion order. And in Kyocera, the court tweaked it a little bit, but I having litigated that with the ITC, their position very strongly out of the GC's office and the commission is that they are not bound by the rules of equity, and until Congress gets around to changing their enabling statute, they're going to keep issuing exclusion orders.
So all of these attempts to fix trolls in district court will only give them more and more impetus to go to the ITC, which carries with it a much larger truncheon than no injunction in district court.
My personal view is it's not any of these efforts at reform that is going to start cutting back the ITC's docket. It's the USTR's recent letter in the the Samsung Apple dispute, where you get all the way through a $10 million piece of litigation. You get effectively a judgment, a final determination in your favor. The agency issues an exclusion order, and the president decides at the last minute that it's not in the public interest of the United States to exclude cell phones from this market. And I think that's going to make people think twice about using the ITC. If I go to district court, I may have to file subsequent cases in other courts to shut the product down, but I can do that with 5 or 10 different ports and not have to worry about the ITC. And to Microsoft's issue, Microsoft's got a currently pending case where they have sued the ITC because the U.S. checks only 2% of containers coming into the country anyway. So exclusion orders really don't necessarily work.
I would also add that the ITC is a very limited use to a non-practicing entity. You know, number one, you have to actually have a licensing program already in place for the patents that you're going to put in there. So you have to have some licenses, and you had to have spent some money on it. And then it only stops imports. So you get an exclusion order, but it's only excluding things coming into the United States. So NPEs who are doing enforcement in Vermont or whatever for local problems wouldn't have much benefit to the ITC.
Great. Food for thought. Thank you. I want to thank everyone on the panel, and thanks to Penn and Christopher Yu.
Attending, and if you're interested, please sign up for the website for future events.
This is permanently on. I can't get it to turn off. Be careful what you say.